Hello. There are situations where a will was formed in a foreign or another jurisdiction, other province or abroad, in the United States, in Europe, in Australia, in New Zealand, India, so forth, Israel, and some asset is located in Quebec. So technically, foreign probation does not automatically validate a will in Quebec. Like, probation is a validation process, and it's done differently in different jurisdictions. So what do we do if somewhere elsewhere in the world somebody died, left a will, valid will in that jurisdiction, with a validly appointed executor or trustee or administrator or liquidator, depending on like how they call it there. But some assets, maybe a bank account, maybe some immovable property, maybe some investment, maybe some insurance, is located in Quebec. So the person did not reside in Quebec, the person who died did not die in Quebec, but still. Well, when it comes to immovable property, the situation is more or less clear, but it's less clear with a bank account, for example, because banks are very much often not only local, there might be a local branch, but the banks are located in many jurisdictions also. So that there might be a confusion here. How do we usually deal with that? Technically, there are two ways. In Quebec, there are three kinds of valid wills, as you probably know. One is a notarial will, a will that was made by a notary in Quebec and properly registered. Apparently, we're not in this kind of a situation, though it might be that there is some old Quebec will, but a newer foreign will, which technically revokes all the previous wills, but only once it's validated in Quebec, for example, which might again add to the complexity of the case. Or there was no will at all, at least no notarial will. There are other two potentially valid wills in Quebec, a handwritten one, where the testator, the deceased, just had written with his own hand, signing with a date or what he or she wanted to be his or her last wishes, or a will made before two witnesses. But usually a foreign will, which was properly done by some foreign notary or lawyer, maybe registered there. But for Quebec, it's just a will made before witnesses, because usually there are at least two witnesses with those wills. The idea of witnesses is brought up to ensure the authenticity of the will, so that it's not some texts that actually, yes, even it was typewritten or made on a computer and then printed and only signed by the hand of the testator, but there were two witnesses at least to attest, sometimes three, sometimes four, depending on jurisdiction, to attest that, yeah, exactly, that was that person, and he actually or she actually meant this document to be his or her last will. So it's not only about witnesses, it's about their later attestation that it actually happened. So when such a foreign will, which was already probated in some other jurisdiction, and therefore it's sort of presumed that the proper legal process was applied to ensure that it was an actual authentic document, then it might make it easier to reprobate or to just probate in Quebec this will as a will made before witnesses, where the foreign judgment would be used in about the same way as otherwise an affidavit of one of the witnesses would be used to attest that Yeah, exactly. That's the will. That document is a will, and it was meant to be that. So one of the ways is to probate again. And if the process is not contested, and if there are no many persons to notify all over the world, then it's not so much complicated. But as you can see, it might be complicated. Because first, the judge, for whatever reason, might not be convinced that the foreign probation is good enough evidence of the authenticity of the will. And there might be a difficulty to properly notify, let's say, like 12 heirs and maybe 5 other people who might be otherwise heirs, for example, but for this will, so their interest is so also involved with this probation process and so forth. So sometimes it might be way too cumbersome. And in that case, another approach might be used, because not everywhere, though, but in many jurisdictions, probation is a judgment in itself. Like in Quebec, for example, it's a judgment. And therefore, the civil code provisions regarding recognition of a foreign judicial decision, of a foreign judgment, might be applicable. Thus, in some cases, making it less complicated, where the judge is not interested in like re-verifying everything, but only in verifying the validity of the foreign judgment itself. And if it's not against public order in Quebec and some other particular conditions, but it's not the topic for today, then the fact that it was validly probated by a judgment in some foreign jurisdiction might be simply recognized in Quebec. And that's another way to make it valid. From the practical point of view, it might be a good idea, but again, it depends, because every additional complication, it's like additional costs for the client, for the executor, for the estate itself. So from the point of view of like being bulletproof, it might be an interesting idea to apply for both at the same time, giving the judge a choice. Like, if you wish go that way, please do that. If you wish go that way, please do that. But from the point of view of expediency, often, or at least in many situations, proceeding with the recognition of foreign judgment looks like a simpler way. But if there is any problem with that, because not every foreign judicial decision is actually a judgment in the sense that it's like final, non-appellable, and so forth. In many states, in the United States, for example, the probation is not actually a judgment, a sort of an order allowing an executor to act, or not even executor, sometimes it's a trustee, whatever the term, to act for a certain period of time, and then the process, the estate settlement, liquidation by Quebec term, is over. So the judgment in that sense is not final all the way while the liquidation of the estate is going on. In that situation, if there is a difficulty to prove to the court that it was actually a judgment, that it was final, then going with a probation anew but in Quebec also is a valid option. I understand that it all sounds very much bureaucratic and formalistic, but that's the point. A notary in Quebec, when it comes to a title transfer, for example, a bank in Quebec, when it comes to release of funds, they all need to protect their own responsibility. And their own responsibility is well protected when there is a Quebec court decision validating one way or another this foreign will. And only once it's done, a foreign executor, foreign liquidator can proceed in Quebec about the assets in Quebec. I wish it was simpler, but this is the way it is. Sometimes foreign probation is accepted by some organizations, firms, banks, even authorities, but it might become problematic. So to avoid this problematic side, Quebec probation or recognition is very much advised. Anyway, if you have a particular situation, of course, consult your own lawyer, and remember that if your lawyer from, I don't know, Nebraska is writing to a Canadian bank branch in Quebec, for officials in that branch, a Nebraska lawyer is not a lawyer, because in Quebec, only a Quebec licensed lawyer is a lawyer. So unfortunately, it might be that the executor, the trustee in, again, let's say Nebraska or Australia or New Zealand, would have no other choice but to hire a lawyer in Quebec to proceed. Because again, by the Civil Code of Quebec, an estate, a liquidator of the estate, should be represented by a lawyer. Of course, there are nuances, but this is for the sake of general information. Thank you, and have a nice day.